Thank you very much, operator, and thanks to all of you for joining us this afternoon. My name is Alejandro Mayorkas. I'm the Director of U.S. Citizenship and Immigration Services, one of the agencies in the Department of Homeland Security. The subject of our call this afternoon is to discuss the Secretary's June 15, 2012 directive regarding the exercise of prosecutorial discretion with respect to individuals who came to the United States as children. I'm joined this afternoon by Acting Commissioner David Aguilar of Customs and Border Protection, or CBP, and Director John Morton of Immigration and Customs Enforcement, or ICE. Each of our agencies has a role in this process, and we'll be discussing our respective roles this afternoon. We also welcome your questions and want to leave the majority of our time together on this call to them. I understand that the participants on our call may be of different levels of familiarity with our work as a department and as individual agencies within it, and with the information that already has been circulated with respect to the Secretary's directive. At the outset, I should note that we in U.S. Citizenship and Immigration Services, or USCIS as we are known, are focused on how we can implement the Secretary's directive most efficiently. I want to apologize in advance if we're not yet in a position to answer many of the process questions that you assuredly have. We have not yet determined, for example, how we will collect the information of eligibility and supporting evidence, who in USCIS will adjudicate the requests, whether, for example, service center operations or our field operations, and how quickly we will do so, by way of example. We do, however, plan to engage with all of you as the days progress so that we can provide much sought-after information on as real-time a basis as possible. I am going to review for a few minutes some of the basic information regarding the Secretary's June 15th directive and then turn it over to Director Morton and Acting Commissioner Aguilar to do the same. And before I do so, I want to emphasize a few very critical points. First, the period during which we as an agency, USCIS, will accept affirmative requests for deferred action from individuals who came here as children has not yet opened. We will not accept requests now. They will be rejected, and it is therefore imperative that you help us in communicating this important fact and that we do not receive a volume of untimely requests now. Secondly, we are very mindful of the vulnerability of individuals to notario fraud and to the unauthorized practice of immigration law. We will continue to be very active in getting the message out regarding this prospect. We are help in doing so as well in both spreading and amplifying this very important message for the protection of individuals who may be the subject of the Secretary's directive. Third, we in USCIS have established resources to field questions that you now have and are going to have, and we intend to provide as much responsive information as possible. Our website, where we have posted written information, is www.uscis.gov. That's www.uscis.gov. And we have an 800 line open from 8 a.m. to 8 p.m. Where we have individuals who are equipped to answer your questions in both English and in Spanish. And our 800 number is 375-5283. That's 800-375-5283. Secretary Napalatano's directive has three overarching elements. One, that we are not to issue notices to appear to individuals who meet the eligibility criteria that the Secretary outlined in her memorandum. Two, for those individuals in removal proceedings and who meet the eligibility criteria, they are to be granted deferred action when they have established those eligibility criteria and we reviewed their case on an individualized basis. Three, we at USCIS must establish an affirmative process to request deferred action for those individuals who are not in removal proceedings. And I want to speak to some of the information that we have articulated already in our frequently asked questions, or FAQs, that are posted on the Department of Homeland Security's website and our respective agencies' website, but go over it just in case many of you have not seen that information yet. And let me do so now. The first question, of course, is who is eligible to receive deferred action under the Secretary's new directive. And pursuant to the Secretary's memorandum, in order to be eligible for deferred action, individuals must, 1, have come to the United States under the age of 16, 2, have continuously resided in the United States for at least 5 years preceding the date of the Secretary's memorandum, and are present in the United States on the date of the memorandum. 3, they must currently be in school, have graduated from high school, have obtained a General Education Development Certificate, or G certificate, or are honorably discharged veterans of the Coast Guard or Armed Forces of the United States. 4, have not been convicted of a felony offense, a significant misdemeanor offense, multiple misdemeanor offenses, or otherwise pose a threat to national security or public safety. And 5, not be above the age of 30. Individuals will have to have completed a background check as part of this process. To explain what is deferred action, in summary, deferred action is a discretionary determination to defer removal action of an individual as an act of prosecutorial discretion. It is important to emphasize that deferred action does not confer lawful status upon an individual. And in addition, although an alien granted deferred action will not be considered to be accruing unlawful presence in the United States during the period deferred action is in effect, deferred action does not absolve individuals of any previous or subsequent periods of unlawful presence. We are working on, as I mentioned earlier, an implementation plan, and we'll keep you informed on a real-time basis of the issues that we are addressing in the development of that implementation plan, and work with you to effect resolution of issues that you will have and that we as an agency will have in the implementation process. A question that we have heard asked and that we knew would be asked and that we answered in our frequently asked questions is, are individuals who receive deferred action pursuant to the new directive eligible for employment authorization? And the answer is in the affirmative, yes. That individuals who receive deferred action will be eligible for employment authorization and EAD, as it is commonly known pursuant to existing regulatory authority. Next, the period of deferred action will be for a period of 2 years, and it is subject to renewal. And when an individual seeks the renewal of the 2-year period of deferred action, individuals will also need to reapply for an extension of their employment authorization. We will, as an agency, and I know that this is echoed by both Director Morton and Commissioner Aguilar, that the individuals who will be using prosecutorial discretion in our respective agencies will receive special training to ensure that the Secretary's directive of June 15th is executed both in its letter and its spirit. As I mentioned earlier, people who wish to avail themselves of this new process will undergo background checks before they can receive an exercise of prosecutorial discretion and receive any accompanying employment authorization. The documentation that we will consider, whatever documentation individuals submit to us, the types of documentation that We have contemplated are such things as financial records, medical records, school records, employment records, and military records. And this type of documentary evidence will go to such issues as proving that the individual who seeks deferred action came to the United States before the age of 16, that the individual has resided in the United States for at least 5 years preceding June 15, 2012, the date of the Secretary's memorandum, proving that the individual was physically present in the United States as of June 15th, and proving that the individual is currently in school, has graduated from high school, or has obtained a GED certificate, or has satisfied the criterion of being honorably discharged veteran of the Coast Guard or Armed Forces of the United States. We will separately and collectively take assertive action if someone seeks to take advantage of this process by making material misrepresentations to us. That is something that we do not condone under all of our existing practices, nor will we condone it under this new process that is established in the directive of June 15th, and we intend to address that quite vigorously. Individuals who come before USCIS, and forgive me if I'm going very rapidly, but I want to try to cover as much ground as possible before turning it over to Director Morton to do the same, and we really want to leave ample time for your questions. Individuals who come before USCIS affirmatively seeking deferred action under the process that the Secretary announced this past Friday, if in fact those discretionary decisions result in a denial because we have determined on an individualized basis that the eligibility criteria have not been met, or there is a meritorious reason to deny a grant of deferred action. For example, someone has not passed the background check. We will, of course, depending on the reason for not that individual not having passed the background check, our notice to appear policy, which is published on our website, will be operative. So we will not be automatically placing individuals who have been denied deferred action into removal proceedings, but will be doing so only consistent with our notice to appear or NTA process, and I would encourage you to review that process as it is published on our website. We, in an effort to ensure the quality of our review and consideration of deferred action requests, set up protocols for supervisorial review to ensure adherence to the letter and spirit of the Secretary's directive, and also to ensure consistency in our determinations of those requests. We will not have an appeal process should we deny an individual's request for deferred action. If, in fact, we grant, and when we grant, I should say, deferred action to an individual under this new process, their dependents and other immediate relatives will not receive deferred action as a matter of course, but rather their dependents and other immediate relatives will have to qualify for a grant of deferred action on their own merit if they meet or by meeting the eligibility criteria that I briefly summarized and that are outlined in the Secretary's directive of June 15th. We are currently exploring the important question that has been already posed to us, whether a recipient of deferred action under this new process will be able to travel outside the United States during the period of deferred action, and that's one of those questions that we will be engaging with you on, and we will be answering through the engagement process as the days unfold. As I mentioned at the outset, in order to obtain more information about this process as it involves U.S. citizenship and immigration services and the affirmative requests that we will field from individuals who are not in removal proceedings, I encourage you to monitor our website at www.uscis.gov. We will be publishing notice of our engagements, and we will be engaging with you on a regular basis, and also to access our 800 number during the hours of 8 a.m. to 8 p.m., regardless of whether you speak English or Spanish, and that 800 number is 800-375-5283. And let me turn it over to Director John Morton of ICE. Thank you, John.
Thank you, Director Mayorkas. So for all on the call, ICE as well has posted information about its role on its website, www.ice.gov, both on our main website and on the section of the website that is dedicated to our public advocate. We also have a hotline, a 1-800 number that people may call during normal business hours to inquire about the process at ICE. That number is 1-888-351-4024. Again, 1-888-351-4024. And like the CIS hotline, it can be called both in Spanish and in English. With regard to ICE's specific role, it breaks down into three parts. First, working with CBP, we will ensure that qualifying individuals under the Secretary's memorandum are not removed from the United States or placed into removal proceedings, assuming on a case-by-case review that they meet the criteria outlined in the Secretary's memorandum. Second, for those in removal proceedings, ICE will take steps to identify those individuals who qualify under the Secretary's memorandum and grant them deferred action, which will mean the end of their removal proceedings, and subsequently refer those individuals to Citizenship and Immigration Services for the consideration of work authorization as appropriate. The review of the cases in proceedings will also be done on a case-by-case basis, but we expect to cover every single person. Importantly, as many of the people know on this phone call, ICE has already been conducting a review of every single case before the Executive Office of Immigration Review, and we have identified a number of people that qualify for relief under the Secretary's memorandum. Those individuals have already been offered or granted administrative closure. We will take those cases now and grant them deferred action. We will continue our review of the full immigration court docket to see if there are any additional cases that we need to consider and grant deferred action to. And finally, we will, in the coming weeks, outline a process whereby people who are in proceedings may identify themselves to ICE for consideration. That is, people who are in proceedings who feel that our case-by-case review has missed them, and they nonetheless feel that they qualify for relief under the Secretary's memorandum. We will establish a process by which those individuals can raise their hand for consideration at ICE for deferred action. Again, limited strictly to people who are in proceedings. Finally, our third piece is that we will be aggressively investigating notarial fraud on individual applicants and widespread fraud on citizenship and immigration services, and we expect to work very closely with Citizenship and Immigration Services to ensure that this process is one that is marked by integrity and is free from with that, Alejandro, I think I will turn it back to you.
Thank you very much, John. Let me, if I can, just add one thing to John's comments, and that is that when ICE grants deferred action under this new process, if in fact an individual seeks work authorization, they will need to file a request for work authorization from U.S. Citizenship and Immigration Services. So it takes that affirmative step when ICE grants deferred action. Let me now turn it over to Commissioner Aguilar of CBP.
Thank you, Director Marcus and Director Morton. CBP's part in this is probably going to be more in the area of an encounter that occurs between CBP enforcement assets, either Border Patrol agents or OFO officers at the ports of entry. So I'd like to go over a couple of the things that I think are critically important for this group. Upon the encounter happening between an individual that may qualify, may be eligible for this, bottom line, this is what's going to happen. Once the encounter occurs, there will be an interview. Once the interview occurs, we will establish the status, the alienage of the individual. At that point, we will probably detain, and this is critically important that this group understand, because there will be a need to detain in order for us to continue the interview process and establish any kind of eligibility criteria that these individuals will put forth. During that interview and detention period, there will be a background check that will be run and must be run against these individuals. What that background check will consist of is a biographic and a biometric background check will consist of running against all available databases sustained and maintained by DHS, other government law enforcement agencies, and some state and municipal agencies also. Upon establishing the eligibility on a prima facie case for deferred action, the processing will follow. At that point, the individuals will be released. Now, at this point in time, we are still establishing the need to process and release. That determination will probably be established by the end of the day or in the next day or so. I can share with this group that over the weekend, there was a total of 11 individuals that were, in fact, encountered by CBP assets, and that's by Border Patrol and at the ports of entry. Each one of these individuals that met the eligibility requirements were, in fact, allowed to leave and basically directed to report to CIS post the 60-day time period. In addition to that, one of the questions that has been asked is, should individuals who are not in removal proceedings but believe themselves to be eligible for an exercise of deferred action upon this process seek to place themselves into removal proceedings with either ICE or CBP? Our answer would be no. Our answer would be that they should direct themselves to CIS, again, after the 60-day time period, once the ability of CIS to receive these individuals is established. So for CBP, it's critical to understand that we will detain, we will interview, we will run biographic and biometric checks, and upon establishment of the criteria, we will release appropriately and direct to CIS. Ali, in the interest of allowing for more questions, I think that does my part.
Thank you very much, Commissioner. Everyone, if I may, we thought it very important to have this engagement as soon as possible following the Secretary's memorandum and the President's remarks of Friday afternoon. I want to underscore a point that I've already shared with all of you, and that is that the engagement process doesn't end today. Quite frankly, it just begins. We understand that there are different levels of familiarity with what deferred action is and what it isn't, and what the process will be and what it won't involve, and we will be engaging as frequently as both we as an agency need in the service of good government and as the community needs in the service of ensuring that all of you understand the process as it is being developed and have a voice in the formulation of that process to ensure its clarity and efficiency. And with that, operator, I think we'll open it up the lines for questions, and if you would please just identify yourself by name rather than affiliation in the interest of time.
Okay, thank you. As a reminder, if you would like to ask a question, please press star 1 on your phone and record your name when prompted. Moment, please. Our first question comes from Jason Gans. Your line is open.
Assuming that a case is denied for whatever reason, and the person is merely an overstay, will the person be not put in removal proceedings? That's question number 1. No criminal issue. For some reason, the case has not perfected the case. Is purely an overstay or an EWI. Will they be put in removal proceedings?
So that question, thank you for that question. The answer to that question would be governed by our notice to appear policy, which is published on our website. That outlines the circumstances under which an individual who has been denied a benefit, or in this case, denied an exercise of prosecutorial discretion, would be referred to Immigration and Customs Enforcement for removal. And I think that you will find that if those are the facts and those are the universe of facts, the referral would not be made.
Okay. Second part of the question, when this program is over, assuming that it will end sometime, will those names be used for removal proceedings?
There is no intention at this point in time to dismantle the architecture of prosecutorial discretion that has been built over the past 1 year plus. So there's no intention to dismantle that architecture. Now the framework of prosecutorial discretion that has been built over more than a year remains in place.
Thank you very much.
Thank you. Operator?
Next, we have Bill Magayas. Your line is open.
Hi, good afternoon. Thank you for the opportunity. My question is regarding what about the children who are not yet in the high school? They are in the middle school probably, or in elementary school, but meet the requirement about the 5 years, or also they came in before the 16. Thank you.
So the question goes to the eligibility criteria that I outlined at the beginning and that are captured in the Secretary's June 15th memo, and it indicates that individuals must have come to the United States under the age of 16, and in order to make an affirmative request of deferred action of U.S. Citizenship and Immigration Services, they must be at least 15 years of age.
Oh, okay. Wonderful. Thank you very much.
Thank you very much. Operator?
Next, we have Elizabeth Marar. Your line is open.
Hi, I actually have a number of questions. The first one is the criteria that have been set up, do those have to be met prior to or can those be met at a future time? For example, if someone is 14 now, can they apply when they turn 15 affirmatively? Also, for example, if someone is in the process of getting their GED but doesn't yet have it, can they wait until they have it to apply affirmatively?
Yes. So the criteria that are of a permanent nature, if you will, is they must have come to this country under the age of 16. They must have continuously resided in the United States for at least 5 years preceding the date of the Secretary's memo, preceding the date of June 15th, and be present in the United States on the date of the memorandum. If, for example, an individual meets those two criteria, and they are currently 14, the process contemplates that if they meet all of the other criteria when they turn 15, they will be eligible to request deferred action. So if they came to the United States under the age of 16, if they have met the continual residence requirement and were in the United States as of the date of the Secretary's memorandum this past Friday, if they are, at the time they turn 15, currently in school or have graduated from high school, have obtained a GED certificate, or have been honorably discharged from the Coast Guard of the Armed Forces, if they have met the requirement with respect to abiding by the law, and they're not over the age of 30, So if they reach the age of 15 and meet those criteria, they will be able to then request deferred action under this new process.
Is that the same for then an individual who currently meets all the criteria except he or she is in the process of getting his GED? Could he or she apply then?
Well, remember the criteria, and I would direct you to that, and then I'm going to please, given the number of people that are assuredly eager to ask questions, turn it over to someone else. But remember, the criteria outline that someone must be currently in school, have graduated from high school, have obtained a GED, or be honorably discharged veteran of the Coast Guard or Armed Services. So that is in the disjunctive. Thank you very much.
Thank you.
Operator?
Next, we have Linda Rose. Your line is open for your question.
Yes, thank you. I understand that dependents and family members are not eligible for the benefit, but would they be at greater risk of being evaluated for issuance of an NTA?
No, so let me be very clear, because the way you phrase your question may mislead people. The dependents and immediate family members are not eligible for deferred action solely because an immediate family member has been granted it. They are eligible for it if they themselves meet the criteria outlined in the Secretary's memorandum. So the grant of deferred action will be extended to an individual based on our individualized review of the criteria and whether that individual meets the criteria. There is no corollary grant of deferred action by virtue of somebody else's grant. You must be able to meet the criteria yourself. That's a very important point. And the prosecutorial discretion framework that has been established will apply to the dependents and family members of individuals who request deferred action and do not receive it, or, quite frankly, do receive it. Our NTA policy, for example, at USCIS governs the issuance of NTAs, and merely because someone is a dependent or immediate relative, immediate family member of an individual who's come before us, that does not necessarily trigger a notice to appear in and of itself. One must qualify, if you will, for a notice to appear by virtue of one's conduct or status. And john-morton's prosecutorial discretion memoranda of last year and since outline the circumstances under which one becomes a priority for enforcement action. Operator? I hope I answered that question.
Our next one comes from Jorge Barron. Your line is open.
Thank you all for this conversation. My question is regarding the timeline from what Commissioner Aguilar just said. It sounded to me a little bit like USCS might need the full 60 days to issue these guidance. And so I would love some information about what your expectation is, Director Mayorkas, on when the process will be announced, just so that we can let community members know. And then a related question is, and I realize this is very specific, but people have already asked me this question, is when exactly is the cutoff date for when people must have entered the country in terms of 5 years before the issuance of the memorandum? Is it June 15, 2007 or June 16, 2007? Thank you.
So on that last one, I apologize. I don't want to misspeak there. Whether it's June 15th or June 16th, we'll get resolution of that. The Secretary has directed our agency, USCIS, to implement this new process in 60 days. That's 60 days from June 15th. It is a significant undertaking for our agency. One of the reasons why we intend to engage regularly with the community is so we can give visibility into the issues that we are addressing as we develop the implementation plan more so than we already have, and so that everyone has visibility into that which already has been developed. So we really want to achieve great transparency, and we'll be posting notice of our public engagements on our website, and we'll be equipping our colleagues who man the 800 number with that engagement information, so they can spread news of those engagements in real time. Operator?
Our next question is from Shaheen Ahmed. Your line is open.
Hello? Yeah, hi. My question is it important for a child to be under 16 can apply, or when he or she is 20 or 21 and has stayed over 5 years and besides is eligible for JET diploma and all other 4 requirements?
I would, if I can, direct you to the USCIS website, www.uscis.gov. You will see links there to the Secretary's memorandum to frequently asked questions that really do, I think, an excellent job of answering some of the foundational questions that you might have, the questions that all of us in the Department of Homeland Security anticipated. You must be 15 in order to request deferred action.
Okay.
And you must have, in order to be qualified for deferred action under this new process, and I should say I'm speaking of just this new process, you must have come to the United States under the age of 16. Thank you very much. Operator?
Next we have Elizabeth Marcucci. Your line is open.
Oh, hi. Thank you. I had a question about if there's going to be a way that we can look at the documentation that individuals will be given. Have you started to talk about this at all at USCIS and sort of what that might look like?
So that's a very important question, and we are in the process of developing that framework. What will be the documentation? What will be the form through which people will submit their request, as well as their supporting evidence? What is the notification that we will provide people to confirm that we have received their request? What is the documentation that will confirm the decision that we make on their request? All of those are questions that we are in the process of answering now, and we will keep everyone, as I mentioned, updated in as real time as possible.
Okay, and the second one, just because I know there's quite a few on a coalition that I belong to that we're a little bit concerned about the definitions of significant misdemeanors and non-significant misdemeanors. And I know that there's been like similar discussions when there was like the TPS applications that looked at different low-level misdemeanors such as DUIs. Is there going to be a forum where we can have dialogue about this? And I think that's a really big issue, especially for youth that might not realize the difference between a non-significant misdemeanor and the significant one. So is that something that has been discussed, and is there guidance on that you can provide as to what you're looking at?
On the question of the serious misdemeanor convictions, that's something that we'll be working on with CIS and the department as we put together the final criteria, and something that we will also be considering in our stakeholder engagement. That said, I can tell you that the kinds of things that we are considering are the offenses that we use now at ICE, and those are serious misdemeanor offenses, typically surrounding assaults, driving under the influence, drug trafficking, arms trafficking.
Yeah, I guess it's the driving under the influence one that doesn't seem as serious to some folks as the trafficking, especially in lieu of sort of the different memos that I know a lot of groups like IDP and NYU Law School forwarded in terms of sort of those distinctions. So I don't know if that's guidance that you guys are thinking about looking at again.
Driving under the influence will be covered.
Covered as
a serious
significant? It is a serious misdemeanor. Okay, thank you.
Let me, if I can, just because I know that this area is going to be the subject of tremendous interest, our frequently asked questions address what offenses qualify as a felony, what offenses qualify as a significant misdemeanor. Many non-significant misdemeanors constitute multiple misdemeanors, making an individual ineligible for an exercise of prosecutorial discretion under the new process. If I can just take a moment to read from the frequently asked questions to provide the information that we articulate there in response to your query, what offenses qualify as a significant misdemeanor. A significant misdemeanor is a federal, state, or local criminal offense punishable by no more than 1 year of imprisonment or even no imprisonment that involves violence, threats, or assault, including domestic violence, sexual abuse or exploitation, burglary, larceny, or fraud, driving under the influence of alcohol or drugs, obstruction of justice or bribery, unlawful flight from arrest, prosecution for the scene of an accident, unlawful possession or use of a firearm, drug distribution or trafficking, or unlawful possession of drugs. Hopefully that provides some clarity, and you'll see further information in the FAQs.
Right.
Thank you. Operator?
Next we have Piedra Martel. Your line is open.
Yes, thank you very much. My question is the time frame between the application for eligibility, the background check, and the granted or denial deferred action will be?
So that's an important question that I don't have an answer to yet. That goes to essentially what is going to be our processing time between the time that we receive, that we accept a request, and the time that we render and communicate a decision on that request. And that is going to be a function of a number of factors, to include, for example, the process that we finalize for the receipt of the request and the volume of requests that we receive. So that is going to be a question that we will answer, and it may be an answer that evolves over time, quite frankly, as we gain efficiencies and as the volume of requests vary. But we're very mindful of the need for some predictability there, and will be as responsive to that need as possible. So thank you for that. And I'm sorry I don't have more information. Operator?
Next we have Larry Keller. Your line is open.
Yeah, I was wanting to know on the college, how many hours they need to be enrolled in college. And if you have someone, I'll give you an example, meets all the eligibility, graduate from high school, and has a baby, has not gone to college. If she goes to college in September, would that make her eligible at that time?
I think that some of those more precise questions will be in a better position to answer as our implementation plan develops. So I'm sorry that I cannot answer that with the granularity that you requested.
Okay.
I don't know. You know, the criterion of being in school speaks of being in school. I don't know that there's any minimum of time that one has to have been in school, but we'll provide further guidance on that further along in the process.
So you don't know how many hours they have to be enrolled in college?
I'm sorry, we do not.
Okay, thanks.
Thank you. Operator.
Next we have Juan Blanco. Your line is open.
Thank you very much. Thank you, Director Mayorkas, for all the information. I just had a question regarding the people who have been in removal proceedings and have a final order of removal. Would those people qualify if they qualify under the other criteria?
Yeah, yes, this is John-Morton. They will qualify. The important point is that they will be handled at CIS and not at Immigration and Customs Enforcement if they have a final order but are no longer in removal.
Okay, thank you very much.
Thank you. So the fact of a final order does not in and of itself disqualify someone. Someone must meet the eligibility criteria, and they must affirmatively request deferred action of U.S. Citizenship and Immigration Services. So thank you. Operator?
Next, we have Margarita Solorzano. Your line is open.
Hi, my question is, what about the people who had just turned 31, and if they have finished their college degrees, either 2-year or 4 years? My question is, if you have habilitated a line where to report abuses, especially public notaries or people trying to take advantage of this opportunity.
So I appreciate that. Let me answer your questions in the order in which you asked them. It is important that as of the date, you understand that the criterion is that as of the date of the Secretary's memorandum, as of June 15th, someone is not above the age of 30, meaning they are under the age of 31. With respect to your second question, I would urge you to use the 800 numbers that each of our agencies and our department has posted as available for learning more information about this process. The 800 number that I identified is an 800 number that you should use to report notario fraud or any practice that you suspect as being one that is exploiting individuals in violation of the law. I also should note that there are many organizations in communities throughout this country that provide resources to individuals who suspect that they may be about to be defrauded or have been defrauded or taken advantage of. There are community-based organizations and legal organizations that provide services either at no charge or at a very low cost, and will provide those services under this new process. It is important to ensure that the services that one seeks are legal services or the services of an accredited provider. And we would really invite you to go to our website, www.uscis.gov. We have a link to these accredited providers on our website, and would really encourage you to reach out to the agencies within the Department of Homeland Security, to reach out to legal organizations such as the American Immigration Lawyers Association for information to ensure that people are not victimized under this new program.
And Ali, if I can add to that, so anyone who suspects notario fraud or a fraud on Citizenship and Immigration Services can always call the dedicated crime hotline at ICE, which is 1-866-DHS-2-ICE. That's 1-866-DHS-2-ICE. It's a permanent hotline. You can report any offense, but including notario fraud and fraud on CIS to that number, and we will handle it accordingly.
And we have given the importance of this, I do want to amplify this message of it. We have an initiative that just recently had its 1-year anniversary, the unauthorized practice of immigration law. initiative, UPIL. We have significant materials on that initiative on our site. We have worked with other federal agencies, state and local agencies. You can contact your state attorney general or local consumer protection agencies. There are very many avenues to not only pursue relief, but hopefully preemptively to ask questions and avoid victimization. And really, to the extent that everyone on this call can spread and expand that message, we would be most appreciative. Operator?
Next, we have Mark Nierenberg. Your line is open.
I'm Mark Nierenberg. I'm in private practice. I want to thank you and congratulate you on the nerve. I've been doing this for over 30 years, and Mr. Aguilar, Mr. Mayorkas, and Mr. Morton standing there in real time. I remember it used to be you had to wait for weeks until things filtered out through interpreter releases or whatnot. But essentially, it sounds that you're treating this as a kind of a TPS program. It's really a hybrid between a class-wide and a case-by-case treatment program, because there's nothing to stop any of the agency members from granting work authorization for deferred action in an appropriate case, even if the guy is 31 1/4. But I understand that you're really not doing it, and I'm happy to hear that just for this limited reason, that it seems that it will feed into a statutory follow-up if you will really hope to specific and closely distinguished different kinds of cases. In other words, you're saying don't apply if you don't fit, even though you could all along.
So I appreciate your recognition and your own appreciation of the manner in which we have engaged on this. I think we all believe that in the Department of Homeland Security and the administration, that given the importance of this, that we engage as soon as possible and on a regular basis. So we appreciate that. This is, while you analogize it to temporary protected status, this is not temporary protected status. That is a program that really is predicated on a very different factual and legal structure that is based on conditions in the country of origin and the inability of individuals to return to that country safely. This is quite discrete and different than that. This is an exercise of prosecutorial discretion, and it is on a case-by-case basis. It is an individualized review of the cases that people present. So thank you very much for your questions and comments. Operator?
Nelson Castillo, your line is open for your question.
Thank you. Director Mayorkas, Director Morton, Acting Commissioner Aguilar, I want to thank you. I want to echo what the gentleman before me, the incredible outreach that you do. It's been unprecedented, and thank you so much. Also want to thank the administration for creating this program to all these individuals who will be benefiting, and I know that you will do your best to adjudicate in a very timely manner, in a very fair manner, all the applications that will be submitted to you. I just would like to encourage you to please allow individuals to travel abroad. A lot of these individuals, as you know, are highly educated. A lot of them are college students who, thanks to this wonderful program, will now have a work permit. And in this day of multinational corporations that allow individuals to require to travel, please allow them to travel for a bona fide reason. Don't make it too restrictive. I would highly encourage you to reconsider your decision to include drinking under the influence as a significant misdemeanor. I don't think it should be. If we talk about the TPS program, as you know, this is a humanitarian program. I would think that deferred action is also a humanitarian program. That under the TPS program, you could have a DUI, and you still are eligible for the TPS. So please reconsider. And finally, sir, I would encourage you all to create a mechanism for those that cannot pay to avail themselves to a fee. I know that under the work permit scenario, I understand that they can apply for a fee waiver. I don't know whether you'll be requiring a fee for the deferred action application, but if you do require a fee, please also implement a fee waiver program. And again, thank you so much for this wonderful program, and I know this is a wonderful step for millions, for many people. Thank you.
And thank you, sir, for your advocacy on three important points: the ability to travel, what does and does not qualify as a significant misdemeanor, and thirdly, a fee or fee waiver. So we appreciate your advocacy on those points. Operator.
Next we have Leslie Holman. Your line is open.
I too second everyone. Thanks and appreciate this opportunity. I have a question for Deputy Commissioner Aguilar. With regard to those individuals who are encountered, first of all, thank you for releasing those 11 this weekend. But one of the things that you said is that they would be detained upon establishing eligibility. And it seems to me that, a lot of the eligibility criteria with regard to felonies and misdemeanors are still being worked out. Also with regard to the ability for someone that is detained who is going to need to get documents, whether it be their proof of their diplomas. And I was wondering if perhaps there would be consideration of having them given the opportunity, rather than detention, to go to deferred inspection, which is typically to return 2 days later, which is typically there for people who may be eligible for a benefit but yet don't have those things that are required.
Leslie, first, I think it's important to point out that, as you reiterated, CBP is already releasing these folks. We released these 11 over the weekend. And maybe I didn't make myself clear. When I talked about detaining in order to establish eligibility, the detention that I am referring to is the detention that's required in order to run the biographic checks, the biometric checks, which really nowadays don't take very long. We should be able to make a proper determination for a prima facie case very quickly. It should not take days. So in that case, we would basically release within hours.
Perfect, thanks. I had written down eligibility, and I see what you mean as eligibility with regard to biometrics.
Yes.
That is terrific, and thank you very much. It's really exciting.
Thank you. Operator, I think we can take 5 more minutes of questions.
Understood. The next one comes from Julie Dinerstein. Your line is open. Excuse me. Next is Brian Large. Your line is open.
Yes, I was curious how USCIS will evaluate juvenile adjudications for purposes of granting deferred action status in accordance with the memo. It was asking about being convicted of a felony offense, a significant misdemeanor offense, multiple misdemeanor offenses, etc.
That is a question that we will answer as we develop a plan. So that's a question that all 3 agencies with the department will answer. The effect of juvenile offenses in the definition of significant misdemeanors and multiple misdemeanors.
Thank you.
Thank you. Operator?
Next we have Thomas Shea. Your line is open.
Thank you, Director Mayorkas and Director Morton and Commissioner Aguilar for holding this national stakeholder meeting. Within our network, there are a number of people who would be eligible under this, the dreamers, who are afraid to come forward because they're worried that if they come forward, their family members might be targeted for investigation or deportation. And I know, Director Mayorkas, that you mentioned earlier about the USCIS MTA policy on your website. I think it would be helpful for the community if there could be a statement that's added on to your frequently asked questions that a person applying or making a request for deferred action under this will not, by that action, cause an investigation of other family members. Because I think regular people are not going to be able to have that ability to go look for the memoranda on the CIS website to sort of make that determination. So if it is that someone requesting deferred action won't trigger investigation of their family, it would be helpful to say that in your FAQs.
Tom, I thought that our FAQs address that point. If you think that we need to add to the FAQs to explain are some of the critical aspects of our NTA policy, we will most certainly do that.
And I just have a follow-up. I think you touched upon this earlier, but I want to be clear that there's not going to be a deadline for someone to request for deferred action under this. So if someone, as you mentioned before, someone could be age 14 now, but they're not eligible to request it. But as long as when they turn 15, as long as they had met all the eligibility requirements as of the June 15th, 2012 memorandum, they would then be able to submit a request for deferred action, right?
So Tom, I think that's the current thinking, and that's the importance of engaging. Is if our thinking shifts on that point, we will certainly discuss it with the community. But right now, I think the plan is that there is not a deadline by which someone must request deferred action, understanding the chronology of events by age and the like that you've identified. But if there's any additional thought being given to that and a discussion to be had, it will be a participatory discussion.
Thank you.
Thank you. Operator?
The next question comes from Ted Hess. Your line is open.
Thank you. Will there be a form, and will there be a fee?
So I think, thank you for those questions. I think that those questions have been asked and quite candidly unanswered, because that's one of those that we'll have to see how this process unfolds with respect to how we collect data and what the financial ramifications of that are. And I'm sorry I can't provide more details than that. Operator, why don't we take two more questions before concluding the call?
Patricia Sobolava, your line is open.
Yes, thank you very much for this opportunity. I have two quick questions. Number one is, I understand the criteria regarding the education piece. My specific question is as follows. If the person is in the process of getting their GED, is that good enough to solicit this benefit? And my second question or recommendation will be just to keep in mind that in the early 80s, a lot of people from Central America had to leave their countries of origin because of the civil wars and all the, if you know, all the corruption and everything that was going on. Given that, many of those children are probably a little bit over 30. Would it be possible to consider extending the age of the person to 35? Thank you very much.
So I appreciate that. I think in response to your first question, as you will see from the Secretary's memorandum, if you have not accessed it yet, it does provide that someone need not have already obtained a general education development certificate, a GED, but as long as someone currently is in school, that criterion has been met, and the criteria that have been outlined do require that someone is not above the age of 30. So that eligibility determination has already been made. Operator, one more question.
Areli Hernandez, your line.
Hi, good afternoon. My question was regarding just the overall multiple misdemeanors, and if that would go back, I know you answered a little bit earlier, but if that would go back to what each state considers a misdemeanor. For example, California would consider driving without a license a misdemeanor. Would those be taken into consideration under multiple misdemeanor offenses?
So we're very mindful, and John, I don't know if you want to jump in on that. We're very mindful of the fact that states have different classifications of offenses. John?
Yeah, as you will see in the FAQ, we are using state definition of crimes as we do in traditional removal proceedings. So it is a misdemeanor, including federal misdemeanors and state misdemeanors, recognizing that some states have different criminal regimes. The number of multiple misdemeanors is set at a minimum of 3.
Okay, so 3 misdemeanors would disqualify somebody for deferred action?
Yes, and let me, if I can, just verbatim read from our FAQs. An individual who is not convicted of a significant misdemeanor but is convicted of 3 or more other misdemeanors not occurring on the same day and not arising out of the same act, omission, or scheme of misconduct is not eligible to be considered for deferred action under this new process.
Okay.
So thank you very much, and thank you again to all of you for participating in this afternoon's call, and we hope you found it helpful. I want to again underscore that we are not request for deferred action yet. We will do so when the process is implemented. The Secretary has directed that process begin 60 days from June 15th, and we're working very diligently to honor the Secretary's direction. It is also very important to be mindful and wary of the potential for exploitation, for notario fraud, or the unauthorized practice of immigration law. We encourage you to pose inquiries and report concerns to the government, to all of us through the websites and toll-free numbers that we have identified, or to otherwise seek the guidance and support of organizations in your communities, or both community-based organizations and legal organizations that can offer guidance, pro bono services at no cost or low cost, and please avail yourselves to the extent you deem appropriate of those services. We will be engaging with you again and shortly and with some regularity as this process unfolds, and we look forward to doing so. Thank you very much to all of you, and thank you, operator.
Thank you for your participation on today's call. You may disconnect at this time.